for yourself on this one. If you were walking down the street and you started to say something, now if someone shut you up because they didn't like the color of your hair, something, would that not be denying a certain natural right of yours to speak your own piece?
We have read all this. Will you please summarize?
Summarize, yes. I believe that the denying of them to wear the armbands was unconstitutional, and the choice of the students was a peaceable choice. There was no verbal put down of government. They spoke their opinion on the Vietnam War through an action, which in turn did not damage or harm any person or thing in the school area. Anything else? And by denying them the right to wear the armband, you're denying them the very right to make this country the wonderful country that it is. And the country and the rules that our forefathers set up for us cannot be denied.
Precedents of this case. 1. Terminello versus Chicago. In this case, Terminello was using racial slander and reference in the speech at one of his sermons. As a preacher of the Catholic Church, you would not expect to find him putting down other races of people. But in this instance, he was verbally discrimination. He was verbally discriminating any difference in skin color or religious belief. Even when we don't believe in what he was saying, or that he was saying the poor things he said, it was still within his constitutional right to express his feelings. The Supreme Court ruled in favor of Terminello because it was within the boundaries of freedom of speech. If the leaders' remarks of this church, even as racial abuse, are considered constitutional, then the wearing of a simple armband in protest of the war should not be even challenged. Number 2. Coleman versus California. In this case, a member of the community of California wore a jacket in the county courthouse with a very vulgar inscription printed on the back. The wearing of the jacket made an uproar in the surrounding environment and was persuaded to the court. The case finally made it to the Supreme Court and was eventually ruled as an act of freedom of speech. The Supreme Court also added that any four-letter word, no matter how vulgar, unless in reference to a sexual act, is within the boundaries of the First Amendment and may not be suppressed by community. If a person can wear an article of clothing with a vulgar expression on the back, why are they questioning the armband in the protest of the Vietnam War? Number 3. Frazier versus Bethel High. On April 26, 1983, Matthew Frazier delivered a controversial speech to 600 members of his church. He spoke of the nomination of a fellow school member to the student council. In this speech, Frazier used sexual reference to simulate the mood of the listeners. Even though few understood what he was saying, the few that did were reciting during this local school day. Because of the context of the speech, the school faculty decided to not let him speak at the coming graduation. The case was taken to the court, and finally it was decided at the Supreme Court that the school was not wrong punishing Frazier because of his speech. They came to this conclusion because of the sexual content of the speech, and only because of the sexual content.
Why did you use Frazier v. Bethel as a precedent?
We chose this specific case because it sets clearly a boundary for freedom of speech, and the boundary sexual content. And it states that any four-letter word in the previous case, any four-letter word, no matter how vulgar, and except the ones with sexual reference, are protected in the First Amendment of the Constitution. And right here, this case set the boundary by the Supreme Court, set the boundary of sexual reference on the First Amendment. There was no sexual reference in this case.
So are you saying that the only reason why the school won was because of the sexual content, and that is the only reason, that is the only thing that violates the First Amendment?
That's right. In this case right here, the Supreme Court members stated that because of the sexual reference, the school did have the right, because that is not protected under the First Amendment.
Members of the Supreme Court, I want you to think hard about your final decision on this case. I want you to realize that the right to choose under the First Amendment, which states that Congress should make no law that restricts people's rights to freedom of speech, religion, press, or peaceable assembly. Realize that showing their feelings about the conflict in the Vietnam War is allowed and should not be stopped. By allowing them to express their feelings, you are not letting them do one of the most essential things in our community, express their feelings. That is what is different in our country. That is what makes us a free country. Without it, you are denying us of the very thing that made our country the very country it is. Don't let it stop you.
Any more questions?
Arguing for the respondents are attorneys Mr. Mike McKellar, Esquire, and Mr. James Yellow. Please proceed.
We are defending the Des Moines School District, and the petitioner, John F. Tinker, was a 15-year-old high school student in Des Moines, Iowa. His sister, Mary Beth Tinker, was 13 years old and attended junior high school. In Des Moines, a group of local citizens elected to demonstrate their opposition to the United States involvement in the Vietnam War by wearing black armbands during the holiday season and fasting on December 16, 1965, and on New Year's Day. The principals at the Des Moines High School were informed of the decision and adopted a policy that any student wearing an armband to school would be asked to remove it, and if the pupil refused, he would be suspended from school until he agreed to return to school without the armband. The Des Moines School District made a rule to avoid the